Hi, everyone. I'm Spencer Pauly, and I'm here today with TJ Martinell, and we're talking about a recent story of his showing emails between Seattle-based private law firm Perkins Coie and the Washington State Attorney General's office, collaborating on an amicus brief filed against the Trump administration. Now, TJ, why don't we start off here? If you can just walk us through the timeline of the communications between Perkins Coie and Attorney General Nick Brown's office.
Yeah, so what happened is Trump filed he signed these executive orders canceling contracts with Perkins Coie and also revoking their security clearance. Perkins Coie filed a lawsuit on March 11th, and the Attorney General's office filed an amicus brief or friend of the court brief on the 12th, so the day after. Mm-hmm. Emails show that they were in communication days before this on effectively collaborating on both the lawsuit and the amicus brief. So the Solicitor General for Washington State, Noah Purcell, was asking them for feedback on when were they going to file, what are some of the claims they're going to make, what should they include in the amicus brief. You had an attorney with, I believe it was a Deputy Solicitor General, who was giving advice to Perkins Coie on when to file and where to file to ensure that they won their court case. And I think the question people are going to be asking themselves is, why does this matter? Well, there's a couple of reasons why. One is they, at the time of this communication, they had 10 active contracts with Perkins Coie, which they failed to disclose in their amicus brief. Mm-hmm. These contracts effectively make Perkins Coie their attorney. So in 10 different instances. So you have a Washington Deputy Solicitor General giving legal advice to their attorney, but not in the context of their actual attorney-client relationship. They also didn't disclose these communications or the extent to which they collaborated with the court, right? And so the idea of an amicus brief is you're effectively acting as a neutral third party who doesn't have a direct involvement in the lawsuit, right? I think the other thing is that's important for people who are not familiar with law to understand is that all these, or not all of them, but most of these communications had the subject line common interest privileged. And that's something the attorneys put in there. And the reason that matters is because they were trying to get these communications exempt entirely from a public records request. So this meant when the request was initially filed for these emails, the Public Records Office claimed this exemption in which if you got the emails back, they would be completely blacked over. So you wouldn't even know who sent what. You wouldn't even know who sent the email and who it was sent to. And they finally turned those over after a lawsuit was threatened with the Public Records Office because this exemption doesn't apply. Because the reason why is if it were true, if it was common interest privilege, that's effectively an extension of the attorney-client privilege. Mm-hmm. Except the Washington State Attorney General is not acting as a client or an attorney for Perkins Coie in this lawsuit. They're acting as a third party that's not directly involved. So, which is why the records were turned over, because if that were to be upheld, it would be effectively the Attorney General's office admitting, contradicting their own claims in their own amicus brief about their relationship with the law firm.
And so you talked to Pete Serrano. He's the former GOP Attorney General candidate who I believe lost to Brown in the last election. Now, what kind of was he saying the same thing you're saying right now, these concerns about maybe the ethical implications of this collaboration between Perkins Coie and the AGO's office?
Yeah, he also weighed in on other things. One, this is the use of taxpayer dollars to defend private law firms' access to federal taxpayer dollars. So the question is, how is this in the interest of Washington state residents? Because he's not defending Washington state law. He's not even defending any constitutional provision. He's the Washington State Attorney General's office is suing to ensure that Perkins Coie has effectively to force the federal government to use Perkins Coie as their attorney. So effectively, you don't have a right to not hire these people. Is basically what they're doing. And so and also the Solicitor General, Noah Purcell, he's a former Perkins Coie attorney. So you have former attorneys for the law firm using their public office and resources to help their former employer gain financially. That's effectively what Pete Serrano was pointing out, is that this is he's with the Silent Majority Foundation. He's not going to get this kind of advice or assistance from the Attorney General's office.
Right. So I see what you're saying. But you ruffled some feathers here, I guess, when it comes to the Attorney General's office here, based on what I was reading. This is particularly comments you got back from the AGO's Deputy Communications Director. Now, he said he dismissed the idea of ethical concern, calling them what I think absurd fiction. And I would like how do you respond to this stance that their communications with Perkins Coie were routine and appropriate?
Mike Faulk, who's the Deputy Communications Director, responded. He is the only person I talked to, and I reached out to many people, many attorneys, many legal sources, many legal ethical experts around the nation in Washington State. He's the only person. And he's also not licensed to practice law. He's a communications guy. He's the only person to have said that this is fine.
Calling it standard practice, right?
That's what he's saying. But the problem is, I reached out to many, many different people who are licensed to practice law, and many of them are experts on legal ethics. None of them would comment.
Why is that?
Well, let me put it this way. If this was above board, someone would have said something, and I have yet to have a single attorney contact me by email or phone and say, "Hey, I don't understand why this is such a big deal." Not why.
It just
and I would say also, I would be very interested to know who advised him on that statement, because there will be follow-up stories on this investigation that let's just say it's gonna be interesting to see how they respond to that, because what they're effectively arguing is that nobody who has any knowledge of legal ethics would find this questionable at all. And so that's they've definitely planted their battle standard on a very unique hill. So I won't give any away more, but there's definitely more to this story. So people should definitely stay tuned.
And I was going to say that this isn't the first story you've talked about, the AGO's contracts with Perkins Coie. You reported on a prior exclusive. How did you first come across this issue, TJ? I'm curious that, what was the motivation to make you want to dig deeper in, the communications between the two parties here?
So what happened is they filed the lawsuit, and I saw the Attorney General's office filed the amicus brief, and I was looking at it and I thought, Perkins Coie, I've heard that name before. It's a very unique name. And I've been doing this ongoing investigative series of the Washington State Attorney General's office's police use of force database project, which they're doing with Washington State University. So I started going through all the different records and contracts and stuff that I acquired. And I discovered, and the reason why I remembered is because the Attorney General's office hired Perkins Coie to negotiate a subcontract between Wazoo and IBM. And so I was like, so I did an initial story saying, they're defending a law firm that they previously contracted with. But then it occurred to me, do they still have an active contract with Perkins Coie? And I found out that they did. And then I found out that they had actually 9 other ones. So 10 that I've found. So they had 10 active contracts. And again, by itself, it's not. If they had disclosed it with the court in their amicus brief saying, hey, yes, we have 10 active contracts with them, by the way, but we've also opposed them in court over Washington state law. So, let's balance that out. Let's have the context here. But they didn't disclose that. They didn't disclose that they've been in communication with Perkins Coie. And also their attempt to use the common interest privilege exemption really contradicts what they're saying in the amicus brief, and because that's effectively where you have a common legal interest involved, but it speaks to a certain type of relationship that you have that is an extension of the attorney-client privilege. And so you either have common interest privilege communication, or you're a third party filing an amicus brief, but you can't claim that kind of exemption over an amicus brief discussions. Because you're not attorney-client, you're not communicating with them as either their client or their attorney.
Just the whole thing's unusual to me, just for like a state attorney general's office to, offer kind of strategic guidance to a private law firm, one with 10 active contracts or whatnot. Yeah, I have a question for you, TJ, and that's like, what are the broader implications, for public trust in state institutions? Well, when we're talking about like taxpayer funded offices, TJ, which I know grinds your gears, but, like if we're having the AGO appear to work closely with private firms on politically charged cases here, what are the implications we're looking at in a broad scale?
Well, let me put it this way. There was an ethics complaint filed with the state ethics board over these communications and the amicus brief. The executive director of the state ethics board is not only a member of the attorney general's office, but she reports directly to Noah Purcell. And she dismissed the complaint and said it was without merit or didn't apply. And like, you were asked to investigate your supervisor and you said he did nothing, like whatever happened fell outside the purview of the public ethics law, or whatever it is governing public employees in the state. And not on top of that, she's part of the office that she's being tasked to investigate. So this is one of the issues with the state ethics board being staffed by attorneys from the attorney general's office. What happens when you're investigating the attorney general's office? So it's this circular, and I think that that's the interesting thing that really comes out of all this stuff is just the sheer number of conflicts of interest that never get resolved, or that nobody seems to think is a problem. And yeah, it definitely causes people to question like, oh, we investigated this and found nothing was wrong. Well, we don't trust you to make that distinction because you're compromised in some way. You're being asked to do something that goes against, again, there was a conflict of interest with them filing an amicus brief on behalf of their attorney. But if they had disclosed it in the amicus brief, that would have been them being transparent. And I think this goes back to another thing, is transparency. They didn't disclose that they had the active contracts. They didn't disclose that they were in communication with them prior. And they also attempted to conceal these communications from the public through the use of an extension of the attorney-client privilege in a context where it doesn't apply. Or they are that is what they're implying, is that they were acting in these communications as either the client or the attorney. And with them giving advice to Perkins Coie about when and where to file the lawsuit, one could theoretically argue that they were acting as their attorney in that instance.
Right. So
giving them taxpayer funded free legal advice.
That just, we're causing, a lack of public trust here, and these other issues arise from this. And
right. And this is not involving a state law. It doesn't involve a constitutional issue. This is them defending a private law firm's cash flow with the federal government.
Right. It's always about the money.
The money, right?
Exactly. TJ, like you hinted, you're going to keep covering some of this, and I think there's more to come. Right?
Yeah, let's just say, it's definitely, people are definitely going to want to keep stay tuned with this because this story just got hotter.
Well, TJ, thanks. It sure did. We're sweating it out over here.
Oh no.
Well, I look forward to seeing what happens next, TJ, and thanks for talking to us about this. And to viewers at home, thanks for watching. See you next week.